Good afternoon, everybody. My name is Jeff Riddle. I am a member of the Civil Rights Division. Thank you all for being here and attending our inaugural event. We're going to get started here with the Director of the Civil Rights Division, Mr. Brian Snoddy.
Thank you, Jeff. Hello, my name is Brian Snoddy, and I am the Director of the Texas Workforce Commission Civil Rights Division. It is my pleasure to introduce to some and present to others the hardworking folks of the Civil Rights Division. Before I get too far along, I'd like to acknowledge two realities. First, I want to recognize that for far too many Texans, we know that 2020 has been a year of struggle and in some cases, grief and sadness. Our sincerest sympathies and empathy is extended from the bottom of our hearts. Our thoughts and prayers go out to all affected by the pandemic. Quite a few of the CRD personnel have also been personally affected as well, and we are not immune or safe from its grasp. It has touched us all in some way, and ultimately we've all suffered, but we shall all rise together again in a new day. Second, this is the holiday season, and in that spirit, I wish to extend a Merry Christmas and a Happy New Year to all Texans. While 2020 may seem to be the worst of times, this is a season of joy, rest, and renewal, as we have the chance to celebrate with family, friends, and loved ones through the sharing of gifts, time, and moments, and fondly remember the family, friends, and loved ones that may have gone on. May 2021 bring all of Texas new blessings and a spirit of regeneration. So as we move on, I noticed that we have a number of questions, and we've endeavored to answer those questions, and we've tried to do that by answering those during the presentation. So you'll notice that, but due to the volume of questions, we'll have to address some in our future town halls. And we do appreciate your interest. So let's talk about the Civil Rights Division and where it fits into the Texas Workforce Commission and its mission in helping to achieve prosperity. TWC is hard at work. It's hard at work developing the workforce, providing support services, including childcare for targeted populations, participating in workforce training and adult education literacy programs, providing services for people with disabilities, administering the unemployment and the tax programs that many have needed to use. But not only does it do that, TWC has a division called the Civil Rights Division, and what we do is we seek to reduce discrimination in employment and housing through education enforcement of the state and federal laws. So what we're going to note here is that like any good engine, you need a bit of oil in it or it can seize up and overheat. CRD plays that role as we seek to reduce discrimination in employment and housing. The Civil Rights Division is one of 13 divisions under the umbrella of the Texas Workforce Commission. The commission structure has 3 commissioners, a commissioner for the public, a commissioner for employers, and a commissioner for labor, where one of the commissioners by designation of the governor sits as chair. The Civil Rights Division is one of the smaller divisions in terms of personnel assigned, but we have a large and a mighty role in the state of Texas. Let's look at our mission, vision, and services that we provide. Our mission is to reduce discrimination, as we said previously, in employment and housing through education and enforcement of state and federal laws. Part of that is a vision that we seek to help create an environment where citizens of Texas may pursue and enjoy the benefits of employment and housing free of discrimination. There's a very good business case for doing this, where everybody has opportunity to have housing, opportunity to have employment. It's good for the employers, it's good for those that provide housing. And finally, CRD has a role, provide a litany of services: employment and housing discrimination, complaint investigations, training and technical assistance to public, and even we have a robust monitoring process where we monitor state agencies and also the Institutes of Higher Education. So we have a variety of services that we provide. Above all, what we want you to know, though, is that we're here for you. And as our motto says, we're here to protect dignity at home and in the workplace. Moving on, if you look at the structure of the CRD, you'll notice that we're composed of 46 professionals, including myself, that provide housing and employment investigations, provide outreach, training, and monitoring of all state agencies and institutes of higher education. If you notice, there's three sections within the division structure. We have an employment section, we have a housing section. In addition to that, we also have what we call or effectively the OCR, or the outreach compliance and resolutions. As you saw in the last slide, we'll move to the next slide. As you saw, each one of those sections has and possesses a specific level of jurisdiction and authorization under state and federal law. In the fair housing section, they operate under Chapter 301 of the Texas Property Code to ensure fair housing for all in the state of Texas. As a fair housing section, they operate under the what they call the FAP program, or the Fair Housing Assistance Program, in partnership with the Department of Housing and Urban Development. We are one of 3 in Texas and the only one with statewide jurisdiction. In the equal employment section, this team is responsible for intake and investigation of equal employment related matters under Chapter 21 of the Texas Labor Code. As a FEPA, or what we call a Fair Employment Practices Agency, in partnership with our Equal Employment Opportunity Commission, they handle these cases of the employee discrimination and complaints that brought both to the EEOC and through TWC directly. We're one of 3 there, and we're also one of the largest with statewide jurisdiction in the state. And finally, but not least, outreach, compliance, and resolution section. This team is composed of folks that are responsible for the prevention of discrimination through technical assistance and training and outreach efforts. Additionally, we also have a mediation and conciliation program that's robust. Respectively, we use mediations in the employment context and conciliations in the fair housing context to effectively and efficiently resolve those matters. This team also is the one that conducts the certification and compliance of all state agencies and institutes of higher education. So next slide, please. So you've heard me say it before, that we're here for you, but this is not just a slogan. And what we're really proud about is that it has a real world effect, and the things that we do are an effort to try to bring more value to you, our stakeholders and customers. Part of that value proposition is we transitioned to paperless operations in November 2019 before the COVID pandemic. What that means to you is that there's been virtually no slowdown in our ability to process, intake, and handle situations that need to be taken care of in terms of investigation, in terms of mediation, conciliation, and/or technical assistance and education. Further, the CRD staff has been delivering the same level, if not more, services while working remotely through 2020. I would note that we all have many of the same issues and limitations as others. I have a 2-year-old at home, and so we work and do things that are necessary to keep things rolling. But nonetheless, we've still been investigating approximately 1,000 employment cases and resolved. We'll do roughly 300 fair housing matters resolved through the year. And we've had a reduction in investigation length by 50% and a reduction in our backlog by 25%. That is not an accident. That's occurred through the diligence and the hard work of these 46 professionals, including myself at the CRD. Finally, we've helped develop customer-friendly tools so you can understand the process, such as process diagrams. We've began to expand our services to include technical assistance so that you can have the information necessary to address issues before they become a complaint. And we've even created an expanded course catalog to provide topics that are to help you ensure that your staff are well trained, whether you're a housing provider or an employer. And last but not least, you may have noticed that sometimes we'll be using letters of caution here in the future to assist in the reduction and prevention of discrimination. In some cases, there are instances where a matter does not necessarily rise to being a cause case, but we do note that there is some issues that may be serious in the future. And as part of providing value to you as a housing provider or employer, we want you to be able to take advantage of our course catalog. We may make some recommendations through the use of letter of caution. So finally, what I note is that we're here to help you achieve better relationships, strengthen the economy, and achieve a better tomorrow for all Texans. If you have some ideas, please let us know. We serve the people of Texas, and we strive to bring you the best level of value. Without further, I now hand off to CRD's employment manager, Mr. James Fowler, to talk more about why we're here for you.
Thank you, sir. Texas Workforce Commission Civil Rights Division. What we can do for you is give you information to help you avoid trouble. And if there is trouble, we can explain our process for resolving it. James Fowler, Manager of Employment Investigation Section of the Civil Rights Division. Next. First, we have to talk about who's protected by the laws that we administer, Texas Workforce Commission Civil Rights Division. People are protected based on race, color, national origin, religion, sex, including sexual orientation, gender identity or expression, and by disability and age. Also, certain activities are protected from retaliation. Those activities are making a claim or assisting another in making a claim or opposing discrimination. All the relevant statutes have anti-retaliation provisions. Next. So what are the actions that are covered? Hiring, firing, harassment, promotion, terms and conditions, which may include hours, assignments. It could be leave, bonuses, getting assigned to the best clients, any other actions that may hit the bottom line. Right. When it comes to retaliation, any action that would discourage employees from asserting their rights under the statutes are prohibited. Before we talk about complaint intake next, it's important, especially in the case of harassment, to report to HR or to the supervisor or to someone to give an employer opportunity to rectify a problem before making a complaint. Once that complaint is made, we start off by determining if Texas Workforce Commission Civil Rights Division has jurisdiction. Is the employer covered? Is the action that's complained of covered? And is the complaint timely? If there's no jurisdiction, then we're able to refer sometimes to an attorney or other service providers, or sometimes transfer to other state agencies. When we do have jurisdiction, then we draft a charge of discrimination. Once the employee signs that, it becomes official. Employer is notified. Both parties are invited to mediate. If mediation is unsuccessful because either party declined, or if mediation wasn't able to help the parties reach a resolution, then the complaint will be assigned to investigation by one of our 6 full-time investigators. Next slide. Our investigation process is to interview parties and witnesses, gather documents, evaluate the evidence, and then we issue a notice of right to file civil action, also called a right to sue. The investigator and CRD are neutral. They don't advocate for either side. They simply gather the facts, evaluate the facts in comparison with evidence required to establish whether or not there's a violation. CRD's determination is not final. It is based on the evidence we're able to gather at this level, and we try to determine, is it more likely than not that the action complained of was a violation of the statutes. Next. How does COVID-19 come into play in all this? First of all, based on CDC guidance, it's very likely the concept of direct threat applies. This has to be balanced with the ADA requirement to accommodate disabilities. Next slide. So when we're balancing this direct threat and accommodation, what are the things that go into each one of those pans to be balanced? We're going to talk about the concepts, facts, and factors that go into finding that balance. This information can be useful, both employees and employers, to know their footing and to avoid trouble. Next slide. First of all, what is a disability? Under the ADA and relevant state statute, disability is a mental or physical impairment that substantially limits one or more major life activities. That could be major organ functions, walking, communicating, self-care, mental functions, etc. It's not limited to, being blind, deaf, or in a wheelchair. And honestly, it's not most relevant to ask what they have. It's far more relevant and advisable to ask, how is the person limited from performing the essential functions of the job? And next, how can we reasonably accommodate that? Next slide. Reasonable accommodation is modifications or adjustments to the job application process the work environment, or to extend benefits and privilege of employment equally. Some common COVID-related examples could be leave or telework, but there can be an unlimited range of options depending on the specific facts and circumstances. So the employee and employer need to be reasonable and creative to find a solution that's mutually beneficial. Employers need to remember there could be reasonable costs. Employees need to remember that they're not entitled to just anything that they want. There are often compromises that have to be made. Next slide. Direct threat is a significant risk of substantial harm to the health and safety of the individual or others, right? And it's one that can't be eliminated or reduced by reasonable accommodation. It's a common theme here. When you talk about accommodation and direct threat, they go hand in hand. You have to balance them a lot of times against each other, right? But an employer's belief that there's a significant risk must be based on some credible outside information. For example, it could be OSHA, depending on the circumstances, or CDC, American Medical Association, relevant local, state, federal authorities. It can't be just because the employer thinks so. All right. So for a quick example, let's say you've got a cab driver and wants to apply for a job driving a cab, and there are visual requirements. That could affect somebody with an ADA disability related to their vision. And the employer may say, well, we believe that there's a direct threat, and we base that upon Department of Transportation requirements. And that would be reasonable in most cases to rely on to evaluate direct threat. All right, next slide. Again, I want to repeat, it's better if an employer and employee can engage in a meaningful and reasonable interactive process to achieve a win-win solution. But when that breaks down, it sometimes ends up being a complaint for failure to provide reasonable accommodation. When that gets in front of our investigators, the things that they're looking for are: one, is there evidence that the employee or applicant is disabled? And two, did the employee or applicant notify the employer of a disability and need for accommodation? Sometimes the information needs to be specific. Again, it's not focused on what the diagnosed condition is, but it's focused on how the person is limited regarding essential job functions and major life activities. Then three, we look at, is there an effective, reasonable accommodation available? And finally, the fourth, did the employer fail to provide an effective accommodation? And notice it says effective accommodation, not necessarily the first choice accommodation. Next slide. Families First Coronavirus Response Act may come into play. Texas Workforce Commission doesn't have jurisdiction over that. You need to consult with the Department of Labor, but there may be times when ADA situations interact with COVID-19 related situations, and both ADA, state law, and FFCRA may be involved. Next slide. So how do we find the balance? First of all, we ask, is the ADA involved? If not, then we have to think about, okay, is there a religious accommodation? Is there a direct threat, and is FFCRA involved? For example, let's say an employer wants to prohibit beards like mine because they want to make masks more effective. But a person with a religious objection may not want to shave. They need to enter into an interactive dialogue to find a reasonable balance. Is the employer reasonable? Is there guidance that beards reduce mask effectiveness? All right, what kind of job is it? How can we achieve the desired effect of safety and also respect the religious rights at the same time? And how do we balance those? All right. If we're going back to the flow chart, if the answer is yes, there is ADA involved, then we have to ask, is the person that has the ADA disability an employee? If no, then again, we're balancing religious accommodation with Families First Coronavirus Response Act. A note is that if there's an order of quarantine involved, that may trigger FFCRA. And then finally, if the answers are yes and yes, yes, there's an ADA disability, and yes, it's an employee, then we also have to factor in addition to all those other things, ADA accommodation. All right, next, let's test this process with a couple of examples. Next slide. All right, so let's say we have individuals who are at greater risk of contracting the virus or having serious complications if they do contract it. They don't want to return to work yet, but they do want job protection. Right, so we start thinking about, okay, reasonable accommodation. If there's an ADA disability, then accommodation is required. What if they have something like anxiety or asthma? Right, these are two examples of the importance of asking not what the person has or what's the diagnosis, but how does it limit them? Right, if I say that I woke up this morning anxious about giving this presentation, that's probably not enough to say that I have a disability and I get to get out of it as an accommodation. But if somebody has a diagnosed condition of anxiety and it stops them from being able to get up out of bed in the morning, or they feel sick, they can't take care of themselves, then it could be an ADA disability and it's something that would need to be accommodated. Likewise, asthma could be mild and it could be something that doesn't substantially limit someone from a major life activity, but severe asthma could very well be a disability. Next slide. So let's look at the opposite situation. The at-risk individuals want to return to work, but it's the employer this time that's worried. The analysis is the same. We have to look at direct threat and accommodation. Maybe there's telework or isolated area or time, mask, right? Direct threat and accommodation are linked. Next slide. What about when the employer wants to require COVID vaccine for all employees? Direct threat finding by CDC allows for medical tests such as temperature checks, COVID screening, but not vaccinations. In 2009, during the H1N1, EEOC said no vaccination without accommodation. In 2020, in relationship to COVID, EEOC said something similar, but stay tuned, things could change. But for the meantime, encourage may be a better option than require. Next slide. So in summary, there are several key questions to ask before acting so that you can avoid getting into trouble. Is an ADA disability involved? Is the disabled person an employee? Is there a reasonable belief in direct threat? And reasonable means based on CDC, state, local health official guidance. Right? Is there a reasonable accommodation available? If it enables the person to perform the essential functions without unreasonable burden on the employer, then probably yes, it is a reasonable accommodation. Does the accommodation eliminate or reduce the direct threat? And finally, don't forget about if there's an order of quarantine, FCRA is likely to be involved. Here are a couple of resources. Next up, we have Housing Manager Patrick Williams will further explain what we can do for you.
Good afternoon. As James stated, my name is Patrick Williams. I'm the Fair Housing Manager for the Texas Workforce Commission Civil Rights Division. The purpose of today's presentation is to provide you an overview of the Texas Fair Housing Act, the fair housing process. Basically, we want to educate. Slide. Here's the agenda I will follow. We'll review the Fair Housing Act, briefly discuss the 7 protected classes covered under the Act. I'll go into more details about disability, types of discrimination, discuss those housing providers that are exempt from the Act, and then we'll conduct an overview of the complaint process. In the early months of the pandemic, CRD received dozens of inquiries related to COVID-19, but none were covered under the Fair Housing Act. The inquiries were typical landlord-tenant issues. Tenants whose jobs were impacted by the pandemic had questions about paying rent. Some had been laid off, some hours were cut, and they basically wanted to know, well, how do I pay my rent? Can I get out of my lease early? In these instances, the customers were referred to other agencies, local tenant councils. The COVID-19 assistance provided by local, state, and federal governments immediately during the pandemic significantly reduced those inquiries. Slide. Under Chapter 301.015 of the Property Code, the authority to enforce the Fair Housing Act is granted to the Texas Workforce Commission. The Civil Rights Division exercises those duties and responsibility on behalf of the Commission. It is important to note that TWC does not have jurisdiction for all of Texas. In the cities of Austin, Corpus Christi, Garland, and Fort Worth, investigate their own housing complaints. Like TWC, they are Family Housing Assistance Program called FAPS, and they have their own MOU with HUD. However, we do accept cases when jurisdiction is transferred. HUD also conducts fair housing investigations in the state of Texas. As the enforcement arm for the Texas Workforce Commission, CRD enforces the law as written. Basically, we call the balls and strikes based on the facts. We don't advocate for the complainant or the respondent. The purpose of the act is identified on the chart. Slide. The following are the 7 protected classes covered under the Fair Housing Act. Most are self-explanatory. I'll briefly discuss national origin, which deals with nationality, one's ancestry, their culture, language, and beliefs. Familial status includes persons who have children under the age of 18, who are living with their parents or legal guardians, pregnant women, and people who are seeking custody of children under 18. To go further into disability, next slide. The American with Disabilities Act gives civil rights protections to qualified individuals with disabilities. Under the ADA, individuals with disabilities are guaranteed equal opportunity in public accommodations, employment, transportation, state and local government services, and telecommunications. In 2017, the American Community Survey estimated 3.1 million Texans, or 11.6% of the population, had a disability. A disability can be physical or mental. Physical disabilities include talking, hearing, motor functions, body systems, such as respirator, cardiovascular, musculoskeletal. Mental impairments, any mental or psychological disorder, such as intellectual disabilities, bipolar disorder, anxiety disorder, PTSD. As James stated earlier, to be covered under the Act, under the Fair Housing Act, a disability must limit one or more major life activities, such as seeing, hearing, breathing, walking, or performing manual tasks. Slide, please. Any change in the way things are customarily done that enables a person with disabilities to enjoy housing opportunities or to meet program requirements is a reasonable accommodation. This includes both private housing and in federally assisted programs or activities. Housing providers may not, again, housing providers may not require persons with disabilities to pay extra fees or deposits or place any other special condition or requirements as a condition of receiving a reasonable accommodation. If a housing provider decides that a request will be denied, they must first engage in an interactive dialogue with the person who requested the accommodation to explore how an accommodation can be granted. Housing providers, you just can't say no. The Texas Department of Housing and Community Affairs states in part that housing providers have 14 days to respond to reasonable accommodations. The response must be either to grant that request, you can deny that request, offer alternatives to the request, or request additional information to clarify the reasonable accommodation. If you go through that process, you're interacting with the individual requesting that accommodation. Slide. Examples of reasonable modification include installation of a ramp into a building, lowering the entry threshold of a unit, or installation of grab bars in a bathroom. Under the Fair Housing Act, prohibited discrimination includes the refusal to permit, at the expense of the person with a disability, a reasonable modification of existing premises occupied or to be occupied by such person if such modification may be necessary to afford that individual full enjoyment of the premises. This is important. Under Section 504, housing providers are required to provide and pay for structural modifications unless it amounts to an undue financial and administrative burden or fundamental alteration of the program. If an undue burden or fundamental alteration exists, the housing provider is still required to provide any other accommodation up to the point that would not result in an undue financial or administrative burden. CRD has seen complaints where some respondents were not fully aware of the Section 504 requirements. Slide, please. If the physical disability and the disability if the disability and the disability related need for the modification or accommodation are both readily apparent, the provider may not, I say again, may not require the applicant to provide additional information about their disability or the need for the modification / accommodation. An example is a tenant who's a double amputee. I think it's pretty clear of the disability and the apparent need, unless it's something outside of what a double amputee requires. If the disability is apparent, but the disability need is not, you may ask verification of the disability need. An example, we currently have a complainant with an apparent mental and physical disabilities. However, his need is not apparent. The individual is requesting to grow longevity spinach. I thought that was interesting, so I had to look it up. The HOA is asking the homeowner, the individual states the longevity spinach provides nutrients and other things that help him with his disability. The HOA is asking the homeowner to provide documentation explaining the nexus between his disabilities and the need for that accommodation. This will be an interesting one when this investigation is complete. If both the disability and the disability need are not apparent or known, the housing provider may ask for verification of both. A great example is emotional support animals. If a tenant requests an emotional support animal, the tenant must provide documentation from a medical provider that clearly state they have a disability that requires an emotional support animal. The medical provider does not have to be a doctor. The documentation has to state the affected major life activity substantially impaired, and the documentation must establish a nexus between the emotional support animal and the disability. Basically, how does the emotional support animal mitigate the disability affected. The disability affected a major activity. How does it affect that major activity and impact it? Slide. Some types of discrimination practices. It is illegal to set different terms, conditions, or practices for the sale or rental because of a disability or any other protected classes. An example is a housing provider cannot conduct requested maintenance for one race, but not for another. This is illegal. A person may not print or publish a notice, a statement, or advertisement about the sale or rental of a unit that may indicate any discrimination against any protected class. Entry into a neighborhood. This practice is known as blockbusting. A person may not, for profit, persuade someone to sell or rent real estate by predicting an influx of a protected population. A loan official is prohibited from requiring higher down payments from an applicant because the loan officer believes the applicant of that race are less likely to repay the loan. Under federal and state law, it is unlawful to coerce, intimidate, threaten, or interfere with any person because he or she exercised a fair housing right. Federal law also makes it illegal to retaliate against any person because he or she encouraged or assisted another person in exercising their fair housing rights. Disparate impact is a cornerstone of anti-discrimination law that prohibits policies and practices that appear neutral on their face, but that result in an adverse effect based on race, sex, and other protected characteristics. In the housing context, disparate impact is a critical tool to enforce the Fair Housing Act in order to achieve open, integrated housing markets and fight forms of illegal discrimination and segregation. Slide, please. There are exemptions to the Act. It's pretty clear there for the housing of the elderly, for religious, in addition, religious organizations and private clubs can give preference to members if they don't discriminate in their membership. That is the key, discrimination in their membership. If it's open to all, it can be, an exemption is granted. A dwelling with 4 or fewer units, if the owner lives in one. So if you have a owner that owns a 4-plex and the owner lives in one, that owner is exempt. A single family housing sold or rented without the use of a broker if the private individual owner does not own more than 3 such single homes at one time. Slide, please. We'll quickly go over the complaint processing chart. For a customer that filed an inquiry with CRD, the initial contact can be by mail, doesn't happen that much these days, email or phone call, or online complaint system called HDIS, or Housing Discrimination Inquiry Support System. Once a inquiry is received, depending on the number of inquiries, it could take between 30 to 45 days before someone contact you about that inquiry. However, once that inquiry is assigned to an intake specialist, our goal is to have it converted into a complaint or dismissed within 30 days. As James stated earlier, the intake process determines if an inquiry is jurisdictional. If it is not, the inquiry is dismissed. If it is, the complaint will be forwarded to HUD to request dual filing. That's important for us because dual filing is required for us to be reimbursed for that work. All HUD referrals enter the process at the CRD complaint stage. HUD does the intake process for the complaints they refer to us. They determine the jurisdiction. During the investigation, as James stated earlier, we interview the complainant, the respondent, all the witnesses. We gather evidence, we analyze that evidence, and we make a determination based on the facts. Conciliation is offered throughout the investigative process. Conciliation can be done by an investigator, or in some cases will be done by one of our mediators. Conciliations are a win-win for everyone because the parties agree, including CRD. In conciliation agreements, respondents agree to allow CRD to monitor their compliance of that agreement. It is also where we can get the most public relief. And some of that relief is in the form of training, reviewing policies, approving those policies, assuring that those policies are distributed to tenants through their website, posted on in the respondent's workplace. So for us, conciliation is really a win-win. Last performance year, about a third of our resolved cases were conciliations above HUD's threshold. Other outcomes are no cause finding, a cause finding, or administrative closures. Sometimes after the case has been, jurisdiction has been established and has been assigned to an investigator, we do find where it does lack jurisdiction, in that case can be administratively closed. Failure to locate a complainant fails to cooperate with the investigation, and sometimes complainants withdraw the complaint themselves because they've resolved the issue with the landlord, the housing provider, or they just withdraw it because whatever the issue was is okay. Either way, that has to be done in writing before we can close it. When it gets to the determination finding stage, if it's a no cause, the case is closed. If it's a cause determination, the case is referred to the Office of General Counsel for review and then forwarded to the director for approval. It is also referred to mediation for a final conciliation attempt. If conciliation fails, that case is referred to the Office of General Counsel to file charges. Once charges are filed, the case can be settled, sent to an administrative hearing, or a judgment by a court. Most TWC cases have been settled. A note, HUD requires 50% of the complaints that we resolve be closed within 100 days. If that's not possible, we're required to notify all parties in writing. Some good news for our customers and housing providers. Most cases today are being closed under 100 days. Great work by the 11 investigators assigned to the housing section. Slide. Use some COVID-19 resource links. These links provide resources both at the state and federal level. It is important to note that most assistance expires the 31st of December, including eviction moratoriums by the CD's emergency declaration. Again, we are here to help you. If you have questions, please go to our website or call us direct, and we'll be more than happy to assist. This concludes my presentation. I'll be followed by Elena Rodriguez from OCR.
Good afternoon, everyone. I hope everyone's having a good day. Dive on a little bit. My name is Elena Rodriguez, and I am the manager of the Outreach Compliance and Resolution team. Here at the Civil Rights Division, we strive to really provide an enormous amount of education across Texas. The OCR, the Outreach Compliance Resolution Division team here provides educational training of federal and state employment, including fair housing laws across the state. Next slide, please. So what exactly is outreach about? As you see here in our slide, we really want to introduce ourselves to the public and be able to be your source, your resource for your concerns regarding equal employment and or fair housing issues. In addition to what you see here, our outreach team and other tasks that the OCR team does, we also provide training standard reviews, state agency equal employment opportunity training, tracking, and reporting. We also provide annual strategic and training plan development, external Texas state agency training curriculum reviews. Again, this is part of any of our state agencies out there. This is part of your Texas Labor Code Chapter 21. As well as our Civil Rights Reporter. Currently, we have approximately 60,000 subscribers, and that is globally. We definitely would like to continue to keep up that great work and stay with us and subscribe to the Civil Rights Reporter. Next slide, please. So what exactly are our hot topics? As you heard from my colleagues, both James in employment and and Patrick in housing, we still see a trend of disability. And also a general overview of both fair housing and EEO. Our most three popular trainings that we provide externally, both internally to state agencies, institutions of higher learning, as well as we provide externally to private employers and housing providers and other stakeholders. Our EEO overview, disability in the workplace, and sexual discrimination and harassment. We also provide employee-tailored training as well, as I just mentioned. Please, next slide. In the fair housing realm, we here also see that our top areas also involve the overview of the Fair Housing Act as well as the Texas Fair Housing Act. Although similarly situated, there are some distinct differences, and those are some things that you as a housing provider may want to know more about, and reducing those litigation loopholes as you continue to build your business. In addition to reasonable accommodation and modifications and sex discrimination and harassment in housing are round out our top three popular courses that we provide across the state. Next slide. In our compliance unit of the OCR team, this has to do with this Texas Labor Code statutory requirement that every state agency and institution of higher learning go through a 6-year staggered review of the personnel policies and procedures. In addition to that, our Texas Administration Code 819 definitely allows us to do what's known as a risk assessment criteria. As a small program, we do an enormous amount of work, and our risk assessments helps our agencies across the board have consistency. Next slide. So what exactly are we looking at when we are auditing, for lack of a better word, or monitoring our state agencies and institutions, aka universities? We're targeting in 6 specific areas. As you see here, the hiring and promotions, performance evaluations, we're looking at disciplinary actions, workplace accommodations, in addition to equal employment opportunity training that includes sexual harassment prevention. Remember, as a state agency and a state public university, you are required by state law to ensure that your staff are trained within the 30th day of employment
and supplemental training is administered every 24 months thereafter. And lastly, what we also review is compensation. We do provide policy reviews for private entities, but on a limited basis and on a contract basis. If this is something that you would like to be interested in or have some opportunity to learn some best practices and tips, we'd definitely be open to discuss and look forward to hearing from you. Next slide. And as you heard today during this whole course this morning, we really focused on the allegations or the complaints that were intaked by us, by the Civil Rights Division, both on the employment side and the housing side. So how can my employment or housing discrimination complaint be resolved? I think that's probably the most fundamental question many Texans have. And then how can we do it quickly? The investigation process, as you have witnessed here today, is lengthy. But I have an option for you. Come see us. Here in Resolutions Unit, if we can have both parties volunteer to resolve and come to an agreement, we can close the case. Yes, sir. We can definitely close the case. This moves faster than the investigation process all the way around. I will tell you, it does require that both parties, meaning the person or the individuals making the complaint and the employer, as known as the respondent, or perhaps the housing provider known as the respondent, all parties must agree to come to the table to have this conversation. These our mediation or conciliations are conducted with 100% certified state mediators. Your information and dialogue that is discussed during this process is 100% confidential. Next slide, please. Why is it even more important? Well, let me tell you what, it's fast. Resolutions are scheduled within a few weeks of filing a complaint. Successful mediations or conciliations allow parties to avoid that time-consuming investigation and achieve a prompt resolution of the complaint. And let's just be honest, folks. It's very economical. Excuse me. Resolutions is an efficient way, an efficient process that saves both parties money by resolving the complaint without costly litigation. Something to keep in mind, ladies and gentlemen, and members of Texas, as you participate in our conciliation or resolutions team program, you do not need to have legal representation if you do not wish to. There are so many options available to you. Keep in mind that resolutions, anytime you're doing a mediation or conciliation, is 100% confidential. What does that mean and why is that important? Let me explain something to you. When you are involved with our mediators and involved with resolutions unit, all your information is kept separate from investigations, period. All that information is retained with us and that is not shared in the investigation process. Should parties not come to a conclusion, then your case will be moved on to investigation without the information that was obtained during the mediation process. This is how we maintain fairness. The resulting agreement is the product of the compromise by both parties, and it is based on their mutual agreement to the terms, not ours, yours. And another thing, it also enforces that we are impartial. Resolutions unit and our mediation team is impartial to ensure that neutrality. Mediations are conducted by trained mediators who do not represent either side of the parties. Our mediator serves both parties as independent facilitators interested in helping foster a mutually beneficial agreement. Regardless of the conciliation method used, if both parties agree to the terms and conditions and sign a conciliation agreement, the complaint will be closed. Next slide. As you saw, my fellow colleagues, Patrick and James shared a variety of resources for you. I want you to know that OCR, we are your resource. We are here to assist you to find those best practices, offer that technical assistance, tweak your help you identify the best route for carving solid policies and procedures to reducing those litigation loopholes, both in employment and in housing, HR, real estate, and beyond. I really appreciate your time and I look forward to hearing from you. If you have any other questions, please, we look forward to receiving those towards the end. At this time, that currently concludes my presentation, and I'm gladly turn it over back to Mr. Brian Snoddy, the Director of Civil Rights Division. Thank you.
Thank you, James. Thank you, Patrick, and thank you, Elena, for all that information. It's been very much appreciated. Now I'd like to take just a second to speak to the heart here. If you're a former military and you feel that you've been a victim of discrimination, if you've ever felt a loss of dignity just for being who you are, if you're a business owner and you feel like you're just trying to run a competitive business, if you're a housing provider and you're just trying to provide quality housing and make your housing into a home for someone, or if you're a home buyer or renter and you keep getting directed toward a part of town or a different complex, if you've ever been discriminated or disrespected against in word or deed in your job, then we need you to know something. We have been in each and every one of those situations. About 30% of the CRD team are former members of the armed forces. We have run small businesses at one time in our lives. I myself have been an employee. I've been a janitor. I swept floors and made Subway sandwiches. I've even walked the mall doing Gallup polls and been a farmhand. We've owned and rented properties as well. We see you, we hear you, and we know where you're coming from because we have been there. The most important thing that I want you to know today is that we, the CRD, are completely and absolutely committed to ensuring that the fair housing and employment laws in Texas are applied fully and executed fairly for you and without fear or favor. We are you, and we are here for you. Thank you for joining us today. We appreciate you taking the time out of your busy schedules. And once again, I wish you a Merry Christmas and have a Happy New Year.
Hello, everybody. Thank you all for attending. Again, my name is Jeff Riddle, and if you need anything from the Civil Rights Division, our website is there for you. Also, you can email CRD Training at twc.state.tx.us. If you have any questions about anything you heard during this presentation or just a question that you thought of during this presentation, please email us, go to our website. We have all of our contact information there on our website as well. It is at twc.texas.gov. Thank you all for attending, and we look forward to having you at our next event.